Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. All right, now without any further ado, it's my pleasure to turn to introductions of our fantastic speakers today. Going alphabetically, I'll begin with Carmen Alberio. Carmen is a recognized expert in the field of probate, trusts, and estates law with 37 years of experience as a probate attorney for the Los Angeles Superior Court. As a probate attorney for the court, Carmen worked closely with over 55 judges, presiding over probate matters, providing instrumental assistance with the preparation and review of matters coming up for hearing. Her intimate understanding of the proceedings make her an exceptionally knowledgeable and effective mediator of trust and estate disputes, where she's able to provide invaluable evaluation to her dispute resolution practice. Carmen is highly respected in the legal community for her knowledge, skill, and professionalism. She's regularly requested as a frequent panelist and speaker on a variety of probate-related topics for local bar associations in Los Angeles County, and she's currently serving as the probate chair for the South Bay Bar Association, so be sure to check their programming out. Thank you for being with us today, Carmen.
Well, thank you for that lovely introduction, Katie.
Our other speaker today is Bette Epstein. Bette has been mediating trust and estate disputes since 2000, following a remarkable career first as a licensed psychotherapist and then as a trust and estate litigator for over 30 years. She turned her focus to alternative dispute resolution and brings her unique blend of legal expertise and psychological insight to every case she handles. Her clients often face situations fraught with grief, family conflict, and high stakes, but Bette's calm, composed demeanor and profound understanding of the law make her an invaluable ally in the dispute resolution process, where she's available as a mediator, arbitrator, and a discovery referee. As a neutral, she brings her unique emotional intelligence, sharp legal intellect, and psychotherapy background to highly emotional trust and estate disputes, is able to turn conflict into consensus in even the most challenging and complex issues. Thanks so much for joining us today, Bette.
Thank you, Katie.
And now I will turn it over to Bette, who is going to start us off with our program today.
So good afternoon. Carmen and I are really pleased to share our experience. Between the two of us, we have 80 years of practice in the world of trust and estates. So we have lots of stories, lots of experience, and we're glad to share that with you. So just to review our learning objectives today, one is to identify the key triggers in family disputes, really the circumstances that result in the challenges of an administration by a family member or fiduciary. We're going to talk about strategies for managing client expectations, both on the part of the trustee or administrator and the beneficiaries. And then we're going to explore the mediator's role in facilitating practical resolutions. So Carmen and I both serve as mediators in trust and estate disputes, and we have some ideas about how to come up with some interesting resolutions that may be different from what the court would do. So Carmen is going to talk first about how did this happen? How do we end up with family member trustees?
And Bette, it's challenging right now for anybody to accept the office of trustee, and especially challenging for family members. But yet, family members do take up the task for a variety of reasons. They feel that a sense of obligation to their parent, who is usually the settlor, to take on that responsibility. They understand the family dynamics as a family member. They feel that they can deal with the family issues better than somebody else. They may take on the role because they have some unique expertise in running a family business. I've seen several trusts that have large businesses that require unique expertise, and those businesses end up in a trust. They do it because sometimes they prefer to have a family member dealing with the trust rather than a stranger. A lot of them are willing to become trustees without compensation. And the settler usually picks somebody in their family, and I say usually, not always, but usually they have selected somebody that they feel will carry out their wishes as set forth in the trust and the will. So it seems like it's a good idea to appoint somebody as a family member as trustee. You would think so for most of the cases, but sometimes it's not a good idea. In some families, and I've seen this over the years, as not only as working for the court as a probate attorney, but as also as a mediator, I've seen situations where in some family, something happens when one of the parents dies, either one or both of them. The resentments that have been festering in a family for sometimes their whole lives comes to the surface. Um, the parents are no longer there to, hold back the flood of emotions and keep the different parties in check. So having that kind of a frail relationship to begin with, naming somebody in the family as the trustee who's going to be in charge of the trust and the assets adds a new layer of stress on an already fragile relationship. Um, it could be, and it affects different members of the family differently. It could be that the trustee family member who's the trustee starts to lose sight of their duties. They become emotionally involved and upset with their siblings or other family members. They're not performing their duties in an impartial way. Or it could be that they're doing a good job, and maybe one of the beneficiaries who does not understand the process and has resentment will start making unrealistic and unreasonable demands, which is something that you're going to be talking on
Right.
slide.
And just a note to the estate planners in the audience, these are really important conversations to have with your clients when you're doing the plan, because I find that planners don't necessarily ask kind of the questions about how do your children get along and are they able to serve as co-trustees in a business relationship? And later find out that, they weren't even able to sit at the Thanksgiving table together and be civil to one another. And yet the parents have this idea that they're going to be in this business relationship. Or I've also had the experience of the parent choosing the least capable sibling who's not responsible financially on their own, that somehow thinks that they'll rise to the occasion and become a responsible fiduciary. It's unlikely to happen. So I'm not a planner. I never was. So I have don't have that personal experience, but I envision that these are really important conversations that a planner should have in terms of the nature of the relationships among all the beneficiaries and who is most capable of serving as the trustee or the administrator of the estate.
And also the time that it takes because if you're working full time, you have a family, a young family. Sometimes taking on this added responsibility is just too much for some people to handle. And maybe then they should consider appointing a corporate fiduciary.
Right, right. So let's talk about the common sources of conflict. So, um, top of the list are accounting disputes. What Carmen and I deal with day in and day out are accounting disputes having to do with the failure to account, the inability to put together a proper court court styled accounting, and then disputes over minor sums. I recently had a case in which there was a lot of unhappiness about a $5 Starbucks charge. It's like, no, let's not spend time dealing with that. But accounting disputes take up a significant portion of the time that we spend as a mediator. The other are discretionary distributions. and perceptions of favoritism, whether that's part of the estate plan or whether it's because the beneficiaries are not able to agree if there's going to be a non-pro rata distribution on who receives what. The other source of conflict in this area is when there's an ongoing trust administration and there's an income beneficiary who has the idea that they are entitled to more than they're currently receiving. And I'm going to talk a little bit about how you can deal with that. A big part of what we live with in the world of mediation, in these disputes, is unreasonable expectations. That number one, they think that because if it's a trust administration and there's no court oversight, they think that things can happen very quickly. When they can't, we know that appraisals have to be done, possibly tax returns have to be filed, and so they're unrealistic as to how quickly they can receive a distribution. The other thing is certainly the feeling of entitlement, of what they are entitled to in terms of the assets. One of the things that happens in these cases is sometimes they have been given different information from the testator, from their parent or grandparent, than what actually exists in the document. So we'll talk about in terms of how those get contested. And then the other major change is the shift in the business relationship between siblings or step parents and stepchildren, that they went from being just family members and hopefully getting along reasonably well to now being in a business relationship. And they don't seem to appreciate that change and what a fiduciary obligation requires in terms of even putting your own interest behind those of other beneficiaries. If your client is a trustee beneficiary, then the interest of the other beneficiaries need to take priority. As probably with everything, communication is key. It's important in all relationships, whether it's a trust or a state administration. But as they say in real estate, the most important elements are location, location, location. And in my world of trust and estate administration, the key really is transparency, 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 and making sure that beneficiaries know what's going on, know what decisions are being made and why. So that's what we're dealing with. So Carmen, would you talk about the role of the attorney in terms of dealing with clients and expectation management?
Yeah, I think it's so important, Betty. You've mentioned some of the most common sources of conflict. And I think an attorney who is now going to be representing a family member trustee needs to expect that in most situations, hopefully not in all, but in some situations, conflicts are going to arise. Therefore, at the beginning of a trust or a state administration, it's important for the attorney, like you had mentioned earlier, to kind of find out what the family dynamics, not just estate planners, but attorneys that are going to be representing the family member who's going to be the trustee at the beginning of being retained, to help this person through the trust administration process. I think they need to sit down with their clients and talk about what are the family dynamics. Just as you'd mentioned for estate planners, you need to know ahead of time, where the sources of conflict have been in the past, how people have gotten along, what are the role, what has been a source of agitation, and then the most important thing you said, transparency, transparency. It's so true. It's communicating to the parties, not just your client, but the beneficiaries. Just there's a balancing between providing them information and trying to advocate. You don't want to have them assume, the beneficiaries assume, that you are representing them, because you're not. You're representing the trustee. But communicating with first with the trustee, explaining the process of administering a trust or estate, dealing with these kinds of issues are brand new to most people. We as attorneys forget that don't understand the terminology. They don't understand the process. They don't understand many times the actual terms of the trust. I had a mediation about 6 months ago where the conflict was really a misunderstanding between the beneficiary and the successor trustee. The successor trustee had not really carefully, I'm assuming didn't carefully read it or just didn't understand the terms of the trust. She focused on the fact she had power of sale, and she tried to sell the largest asset in the estate, which, according to the terms of the trust, required outright distribution as soon as she became the successor trustee because the settler had died. And so a lot of clients, I get the impression, a lot of clients will nod and indicate to the attorneys that they understand the terms of the trust
Right.
when they don't. And so,
Let's go to the next slide, because
yeah.
I think this outlines some of the issues. Yeah.
Yes, it does. And actually, that's a good part because explaining the process to not only the trustees but the beneficiaries. And one of the things that you, Betty, had brought up was a checklist, which it has been included in our materials. Could you speak to that checklist?
Yeah. So, in working with trust administration clients, then one of the things I found really helpful is to clearly list kind of their tasks. And so we've included a sample checklist. It's not, it's not going to apply to every trust. But the first thing is read the trust instrument and make sure that your client understands what the instrument is. And then, particularly regarding the requirement that they keep good records and that they be able to support an accounting, which would include every receipt, every expense. So it's really gives a roadmap for how to administer a trust. And again, this is just a sample. Different counsel have different approaches, but I thought it would be helpful just to include that in our materials because it too often we don't get accurate accountings because records haven't been kept and the trustee doesn't understand or the administrator doesn't understand that they need to account for every dime, and they do. So this is just an opportunity to, create an environment hopefully that will support your good work that you're doing and advising your client.
And it's something similar in the way of setting a framework and a timetable and maybe to the beneficiaries. I think a lot of times beneficiaries complain and file petitions to have the trustees remove is they don't understand the process, what needs to be done by the trustee, file tax returns, pay bills, prepare an accounting, hold back money for, expenses of the trust, whatever those are.
Something as
Eh,
basic as marshaling the assets. I mean,
yes.
what we find is sometimes the testator has, like 15 bank accounts, that because of the days when you open a bank account, you got a new toaster or whatever the reason was, trying to get a better interest rate. But they have so many accounts and it takes so much time to marshal them.
Yeah,
So,
and also explaining the process of, maybe appraising certain assets, what time they have unrealistic expectations about how long it takes that they can get their money tomorrow. They have unrealistic expectations sometimes of how much they can be given at a certain point in time. So I think it would be helpful, maybe to prepare some kind of a letter to the beneficiaries that doesn't purport to give advice, just basically explains the process. What do you think, Betty?
yeah, I think outlining the process to the
Hmm.
beneficiaries is really helpful and trying to estimate the timing. So they're
Hmm.
creating an opportunity for at least they will have good information. And, whether they agree with it or not, at least they've been provided that information and the object being transparent in this administration.
Yeah, and keeping the lines of communication open, if the timeline changes to let them know.
Right.
Um, I just think if you set up your client for success and you set up the beneficiaries to kind of have an idea of where all this is going, I think it would eliminate a lot of misunderstanding and hopefully eliminate, petitions to remove the trustee.
So, Carmen, talk about the judicial. You spent 37 years with the court. How
I
do they
did.
feel about some of these disputes? What's the general attitude about judges and these trust
Well,
administration or probate administration disputes?
I can say I worked for a lot of judges, but I also sat as a judge pro tem doing probate calendars, so which helped me get a perspective of what the judges look for. And right now, low stakes disputes are something that the judges are going to say, go mediate this, go work it out amongst yourselves, and come back, when we can deal with these other larger issues. The courts, especially in Los Angeles County, are shorthanded. One judge retired last year. They just replaced him this month. Two judges retired in the summertime. One of our probate attorneys got elevated, is now going to be a judge in Riverside County. So the courts, in LA County is overworked and understaffed. And they don't, one of the benefits of mediation is that, you can have an extended conversation with the client and the beneficiaries that you can't have in court. The court is, if it's not ready to go, the court may decide that it's better if you go to mediation and try to resolve these smaller issues, maybe resolve everything. Mediation.
One of the examples I use in trying to help parties understand kind of the interest of the courts or the lack thereof in the issues that they're arguing about is I had a client who actually absconded with $1 million, that he was the trustee of his young nephew's trust after his brother had died and leaving this child with $1 million life insurance policy, and he embezzled it. That gets the court's attention, or cases where someone has, really engaged in self-dealing and invested in their own real estate venture, their own business venture, and then lost that money.
Mhm.
That's of interest to the court. And what we know or what we're told is that generally trust accountings are not interesting. And keeping the court's attention while you litigate those issues and go through line by line of your objections will not be of particular interest to the judge. Is that your experience, Carmen?
It is, and it's not that the court is unsympathetic, it's the court is dealing with time constraints. And because mediation has been so successful in this area of law, um, the court feels that it better serves everybody if they can deal with these low stakes disputes in mediation or maybe among themselves before they come back to court. And the last thing on our checklist here, the potential long-term damage to family relationships. Uh, uh, you know, Having litigation is time-consuming, expensive, and stressful. And a lot of family members who end up being trustee, they didn't expect to end up in court. It takes a toll on anybody involved in litigation, and it should be avoided. And that's why setting up the client for success at the beginning and giving the beneficiaries an idea of where we're going with this process. If that can be set up at the get-go, it would certainly avoid a lot of litigation and taking up the court's time because the court has a lot of cases continually.
The other thing is my experience is that trustees feel they're under personal attack when a petition gets filed questioning their judgment, questioning their administration,
Mhm.
and that it really creates havoc in terms of any personal relationships among the family. So
Oh, yes.
that's, I think, an important consideration in some families. In some families, they have no relationship, they don't want a relationship, and they don't care if litigation will further create hostility among the family members. But generally, that's not the case. But there's no question that that trustees who are the subject of litigation feel like they are directly under attack, as opposed to just them in their role as a fiduciary.
Yeah, and for some of them, like I've indicated, it's the first time that they've been a trustee. In one of my cases, in the mediation, the successor trustee was in total shock that somebody, this was pretty quick turnaround. About 2 months after she started acting as successor trustee, the beneficiary filed a petition to have her removed. She was in total shock that somebody had sued her.
Right,
They're not used to the legal process.
right. So let's talk about some special issues, particularly related to accounting. One certainly is the failure to account, and we see a lot of those cases in which they don't understand what is required to do a proper court accounting, and they don't have the information that's necessary. The second is the lack of transparency. As I mentioned, that's a key to maintaining good relationships in an administration, whether it's a trust or a probate. And one thing that can be done, which can help, is to provide view-only access to brokerage accounts. So they can't conduct business on the account, but they can see the activity. And that can be done in a checking account as well. Most financial institutions are available to provide that kind of online access. And I think that can make a big difference in terms of attitude to feel that you can at any point just go into the website and see what's going on with the account. Another big issue are ATM withdrawals. I can't tell you how many times I've seen pages and pages of ATM withdrawals ranging, typically 200, 300, 400, but day after day, and with no description or no explanation of what that money's being used for. And that what we know is when you don't provide information, that people suspect the worst. So they only assume that that money is not being used for proper purposes unless you can give them really good explanations of why that money was needed. Same for credit card payments with no explanation of the charges. It's not enough that you just pay the bill, but unless you are in a position to provide the statements or an explanation of what the charges were, they're likely to be questioned. So again, transparency in the process can save fiduciaries a lot of grief, because what we know is once objections start being made, they're looking at every dime, trying to find, a problem. And again, just to be aware that the courts are not excited about trust accounting disputes. They don't have a lot of patience to go through them, particularly if they're really small items. As I mentioned, a $5 Starbucks charge that I see in an objection isn't going to get you very far. So to really prioritize what's important, what's worth spending the attorney's fees arguing about. And when I serve as mediator, and you may have two attorneys and a mediator incurring fees, let's be practical and focus on what's really going to make a difference. So let's go on to the next slide. There's more issues that we see a lot of, and that has to do with distribution challenges. So when family members want to keep real property and who's going to get it, and what the value is going to be. And so what we know is that can be addressed in a number of ways, sometimes by auction, where you really just set up an auction to see how much people are willing to pay. Other times people are just willing to pay a premium to get what they want because that's important to them. And the other answer is to sell property. And what we know
Yes.
is for the courts, that's an easy call. If you can't agree, we'll just sell it and split the proceeds according to the distribution plan. But we deal with these issues a lot about valuation. There is almost always missing jewelry. Um, and it's jewelry that people thought existed that may or may not have existed. And then also related to the value of the jewelry. My favorite example of this is I was mediating a case some years ago and between a brother and a sister. And the brother was convinced that their mother had an engagement ring with a large diamond in it. that had to be worth a minimum of $25,000. And he was sure that the sister had taken it and she wasn't being charged, it wasn't being charged against her share. So I went into the room where the sister was with her counsel and I said, "Do you have your mother's engagement ring?" And she said, "Oh, yes, I'm wearing it." And I looked at it and I said to her, "Can I borrow it for just a few minutes?" And I took it into the brother's room where he was with his counsel and said, "Is this your mother's engagement ring?" And he said, "Yeah, that's it." The diamond in that ring was so small, it was barely a diamond chip. And of course, the lawyer didn't have any information other than, the mother had a big diamond in her engagement ring when in fact she had a very small diamond, and probably the ring wasn't worth $1,000. But that's what happens is people really conflate what jewelry is worth. Now, gold is worth a lot these days, so if you have a lot of gold, that might be worth talking about. But generally, there's not a good secondary market for jewelry, so it doesn't have the value. And that goes with household furnishings as well. People think that, they have a house full of antiques. No, they have a house full of old furniture. And very seldom do we see actual antiques with significant value.
And you know what? If there really is a dispute with regard to the sale of the jewelry, have it all appraised. I have a situation where the appraiser came out and looked at all the jewelry and only selected certain pieces that he thought were worth appraising, which right away tells you that a lot of this stuff isn't worth much.
Right. And
Uh,
and appraisals are costly.
mhm.
If you have a lot of jewelry or a lot of personal property, it can be costly. Then there's what got put in storage. And what we know is that the way storage companies make so much money is that people put stuff in storage and then they never take it out. And so it comes up in these cases, these administration cases, with what's in storage. Has there been an inventory done? No. Do we have photographs? Yes, of boxes. What's in the boxes? Nobody knows. And is there anything of value in the storage facility? But we spend a lot of time talking about what is or isn't there and what it's worth. And then who's going to clean it up? That's the other dispute that we deal with. So,
And
and
and getting people to agree to go to the storage unit, pick out what they want, and have it shipped because some of these things are pretty large. I mean, a lot of these things they'll end up being disposed of, or if they're shipped, it's another big cost.
right, right. And with the storage facility, it's the same. When you can't disclose or don't know what's in it, it just creates suspicion.
Hmm.
Anytime it appears that you're withholding information, there's suspicion that there's something more out there that you're not telling them. So again, it goes back to the transparency issue. And then again, whatever isn't agreed upon, it's easy for the court to say sell it. So that's going to be the fallback if you can't figure it out among yourselves. So next are issues related to the estate planning. And we see a number of things. Part of it is estate plans that have ambiguities in them that create an opportunity for family members typically to argue. I had one recently where there was a question of the estate planning document. Did it provide a life estate or a tenancy for years? And the discussion came up in wanting to basically buy out the interest of the person who was given the right to live in the property. And there's a difference in the analysis of whether it is a true life estate based on that person's age or a tenancy for years. And the document was not clear. Fortunately, they were able to come to an agreement. Sometimes we see mistakes in documents where there's no provision regarding the remainder interest. If a beneficiary predeceases the testator, what happens to their share? And again, what this does is create an opportunity for people to disagree. We know in some families there can be some challenges with the documents, and they'll say, well, we really know what mom or dad or grandma wanted, and so we're willing to work with that. Another thing that happens that we see is there's not an ambiguity in the document, but it's different from what was expected. And what we know is testators often tell people what they think they want to hear that may not be what's actually reflected in the documents, but they want to keep peace in the family during their lifetime. So
Mhm.
they provide misleading statements, and it can create havoc. I mean, I understand the purpose of not wanting to be in the middle of a fight at the end of your life, but you're not doing your family any favor by not being truthful about what plans you've made. Better to say you're not telling anybody and everybody's going to get surprised than saying things like, you'll be taken care of. What does that mean? You know, people have a different expectation as to what that means. Is that $10,000? Is it $1 million? What does it mean to be taken care of? And then we have the basic challenges to the validity of the estate planning documents. And we know that those oftentimes are based on lack of capacity and or undue influence. So those are costly claims to be litigated. They typically involve expert witnesses, both interpreting a document or relating to someone's capacity. So we end up with medical witnesses as well as the estate planner, who oftentimes is the key witness that everyone's going to want to hear from. Unfortunately, sometimes the planner's not available, even either because they are no longer capable of testifying or they have passed away. So you're not able to get information. But what we know is that they're they're costly to litigate. I had an interesting case recently in which the capacity of the testator was being challenged, and she had taken advantage of the California End of Life Act and chosen to end her life with the assistance of her doctor. So obviously, there was a determination by the doctor that she was capable of making that decision. And yet the changes to her estate plan that had been made not too long before she ended her life were being challenged. And I thought to myself, if someone has the capacity and the competency to make a decision to end their lives, they must have the capacity or competency to change their estate plan. So the case got settled, but that was an unusual set of circumstances. Sometimes we just hear that people are still making their own healthcare decisions, you know, at the end of their life or at the time that the changes were being made to the plan. But I never had one in which someone had chosen to end their life with the assistance of their doctors.
And so they had to meet that criteria, as you've indicated, which helps indicate that they had capacity.
I would think so. Just, you know, kind of a common sense. There's what could be a more
Yes,
important, you know, critical decision than ending your life. So
exactly.
that person had done that and met the criteria. So, Carmen, talk to us about unrepresented and unreasonable beneficiaries. We know that we have a lot of those in these cases.
Yes, it's very interesting. It just seems to me, Betty, as you know, I do also probate consultations with attorneys, and it seems recently in some of the matters I've been consulted with that in some of these cases there are at least one unreasonable beneficiary making unreasonable demands for information, for distributions, for copies of accountings, although they've already been provided with quarterly accountings for the right period of time that they're entitled to these accountings. And so it's a difficult, I think it puts the attorney for the trustee in a difficult situation because especially when these trusts are not court supervised, to what kind of information and how often are you going to be providing this information to a beneficiary that does not seem to understand that there's a process, there's a time frame, there are sales of assets, tax returns to be prepared. and yet continually, in some cases, send 5 or 6 emails a day requiring a full and complete accounting by the end of the week. Dealing with these folks is difficult. And you want to provide these folks with information in a letter that just explains the process, reiterates that, you've already been provided this information, and that the trustee is doing everything reasonably promptly, and that this is the expected time frame when distributions can be made and the final accounting can be prepared. Um, some of this, I think, makes me think of what we said at the beginning, how to set up your client, the trustee, for success. And part of that is just educating the beneficiaries on the process before they start making all these unreasonable demands. There's always going to be somebody, as in the case that I'm thinking of, that is very hard to satisfy. And it may end up that if this person, cannot be satisfied, that the a final account that the trustee was going to prepare in this unsupervised trust may have to be filed in the court, the last and final account, just to get court orders that indicate that the court has reviewed the accounting, that the acts of the trustee are appropriate, that they were done in a timely fashion, and that the trust can be terminated and distributions can be made after the payment of expenses. What is your thought, Betty?
Well, so what I find is it's often that the challenging beneficiary really has mental health issues,
Mhm.
that they are not emotionally stable or able to incorporate kind of logical thinking into their approach to this administration. And that's difficult. There's no question. I find that as a mediator, I certainly am dealing with people in many cases in which there are serious mental health issues. And you try and work with them in a rational basis. And even with my training as a psychotherapist, I'm not there to be their therapist. I'm a good listener and I'll listen to all that they are concerned about, but it's a challenge. And sometimes it just requires a court order. I must say that not every case is going to get resolved through mediation by any means. And sometimes just hearing from the judge is the only solution.
Yeah, I agree.
So, but let's move on to how to use mediation effectively. Obviously, it's a process we really believe in. It works.
Mhm.
Not every case gets settled, but certainly most do, either at the mediation session. And my goal generally is that by the end of the session, we have a written settlement agreement signed by all the parties so that you've got an enforceable contract. The timing of the mediation can be different in different circumstances. Sometimes we mediate disputes before anything's been filed with the court, but there's just general disagreement on how this trust or the estate's going to be administered, and they want to engage in mediation early. What's important there is to make sure that you've got all the necessary information to give the beneficiaries the level of comfort that they can make a binding decision. So whether that's getting all of the accounting backup data that may be helpful, getting information from the estate planner, maybe even the planner's file without having taken the deposition to see what was discussed. Medical records, although those are difficult unless someone's willing to request them without subpoena power. And then other mediations can occur, 6 weeks before a case is set for trial. So everything's been done, all the discovery's been done, a lot of money's been spent, but they really want to avoid the risk and uncertainty of the person that I refer to as the stranger in the black robe making decisions where they have no control. And one of the reasons that mediation works is that people can tell their story. There's
Exactly.
no objection that something is irrelevant or inadmissible for any reason. They can tell their story. And I find that the first sometimes several hours of a mediation are hearing from everybody kind of what's the backstory, what leads you to be in a position that you're in today. And then the other thing that can really be helpful is when the mediator works with counsel to basically make a plan on how to address the issues. I do pre-mediation calls with virtually every lawyer that's involved in a case. And one of my questions always is, what can I do to help you? That we know that these can be really challenging clients. And so if there's anything that I can do to help you manage your clients' expectations, I'm glad to do that. And what I do sometimes is I give the opportunity for the lawyer to speak with me privately. In my introductory remarks, I say that sometimes it's helpful for me to meet with the lawyers separate. And so if it appears to me that that the lawyer is really being challenged, I may speak with them separately and say what's going to be helpful here.
Betty, I totally agree. I especially feel that it's important to let people tell their story. They're not going to get that opportunity in court, and they need to have somebody hear them, hear their concerns. And I do the same thing. I have pre-mediation phone calls the day before or the 2 days before with the attorneys so that I can focus initially with the client. And it's just amazing how helpful that is to them and to move the process along.
Right. So we don't have much time left, so I'm going to try and go through all of this. So, in terms of helping counsel deal with challenging clients, I try to be the voice of reality at times. And sometimes the client can't hear it from their lawyer, and somehow hearing it from me as a truly neutral person can resonate. So I'm glad to be available to let them know how a may view their circumstances and at times what the likely outcome will be. It's really important for clients to be prepared to deal with what's going to go on at the mediation, both making sure that they have enough information to make a binding decision and understand the process. And clients can be very emotional under these circumstances. There can be a lot of anger, a lot of hostility, a lot of resentment, depends on what went on in that family for the past many decades. And so preparing them for that, I think, is really important. Next is mediation can provide information that isn't otherwise available. And I know sometimes people get critical and say, oh, mediation is just getting free discovery. But obviously, information needs to be shared. And one of the things I do in my pre-mediation calls is I ask if there's information that might be available before or at the mediation that would be helpful. And in a way, act as kind of an informal discovery referee. Because I'm pretty confident that if I ask for the information, it's going to be provided. And so that can be very important. And sometimes there's appraisals, there's backup data for an accounting, there's medical records. I never know what it is that's going to be important. And so I'm glad to be made available for that purpose. And then there's an opportunity for creative solutions that are not solutions that a court would necessarily come up with. So,
Oh, Betty, may I refer everybody to the podcast that you did for ADR with Len Levy? I thought the solution to a particular mediation you did was outstanding.
yeah, so we have a colleague in Los Angeles, Len Levy, who does wonderful podcasts. If you haven't seen them, we'll give him a pitch because they're really good. They're on a variety of subjects. They're not trust and estate disputes necessarily, and he's not a trust and estate mediator. But it was a case study that I did having to do with a life interest of a stepmother who was about the same age as the children who were the remainder beneficiaries. And the idea that she could outlive them and they would never personally enjoy the benefits of their parents' wealth was just appalling. And so we restructured that relationship to buy out her life interest so that they no longer had to be in business together. And as you probably know, there's a formula for valuing a life interest, and it may require some adjustment depending on what the circumstances are. But it really was a way to end the business relationship with people that clearly did not want to be in business together. And so what we know is family peace is important in some families, that litigation takes its toll. And so this is an opportunity to come up with a different approach. Yeah, I see that Katie just posted in the chat the mastery.
Podcast.
Yeah, the podcast in case you want to see it. Um, and then in terms of if it's a trust administration and where the trust has terminated or it's a probate that's going to be eventually completed, how you come up with creative swaps. And that oftentimes can involve tax consequences. Assets may have different income tax bases depending on if some were in a bypass trust and have a basis from years ago. Others are in the survivor's trust and have a more current basis. And so there's lots of ways to figure out how to equalize distributions, treat people fairly. That's one of the things that we can do through the mediation process. So it's really, really important. So Carmen, let's go to the takeaways. What have we learned here today?
Well, I think what we've learned is you've got to create and maintain realistic expectations early and often. I mean, early, at the beginning of the process, not only with the trustee who may be brand new to the office of trustee, but to the beneficiaries who also may be new to being beneficiaries in a trust context. So if people's expectations can be maintained in the real world and realistic, in timeframes, I think then perhaps you wouldn't have the misunderstandings that arise from lack of transparency, lack of communication, lack of updating the beneficiaries as things change during the administration process. And mediation isn't just a tool for resolution. As I highly recommend you watch it's called Masters of Dispute Resolution, and it was Betty's podcast about the widow, because that showcases that the mediator and the attorneys in the mediation process can create a strategy that you wouldn't be able to get in court because of the time constraints that the court has, the little time that they can spend on each case that's on their calendar. But mediation affords you the time to let people tell their stories. And also it's like I called it peeling the onion. You learn something from the mediation briefs, you learn something from the pre-mediation phone calls, you learn other things during the mediation process itself that help you find creative solutions, as Betty did, for resolving the conflict. It was a solution that nobody else had thought of but Betty. And it was just an amazing, I thought, wow, this is just so, I can't compliment you enough, Betty. It was genius. And then I would encourage attorney media collaboration in managing difficult dynamics and, working, we're interested in helping the parties resolve this. That's why we're mediators. And we're interested in helping the attorney, because the attorneys want to get these resolved too. We're there to assist you. We're not the stars that solve the problems. We are there as partners with the attorneys and the parties to try to come to a resolution. And we can't do it without everybody's cooperation.
I
So,
can't tell you how many times when I meet with the lawyers separately, and I'm inclined to do that as the day progresses, I hear from them, you have got to get this case settled. I can't deal with this anymore. I mean, I represented those clients for 30 years. I know how difficult they can be. And, this goes on for months and years, and the lawyers just get worn out.
oh,
So
I know. I know
so
that's true.
I appreciate that sentiment, but it's important because it's challenging. It's difficult work. There's no question about it.
Yeah. It's true. I totally agree, and it's just been it's rewarding when we can get these things resolved. You
Right.
feel a sense of accomplishment, and because not only because you've managed to get the parties to agree, but because it's in their best interest, not only for the attorneys who have to deal with these situations for years because the cases take so long to go to trial in every county in the state, but because of the stress and the financial drain on the parties. Uh, it, you
One,
know, it-
one tool that we have, which can be helpful, and I'll just mention it, is a mediator's proposal. And I use those kind of towards the end of the day when it seems like the parties are stuck, that they're just not making any progress. And sometimes I'm asked to make one, sometimes I offer to make one, but I find it almost always works. And it's after I've had enough information to really able to evaluate the strengths and weaknesses of the case and come up with what I think is a fair resolution. So let's end on that note.
Excellent.
So,
Thank you. You saw me pop back up. That's your
yeah,
kind of time indicator that we're here towards the end of the time. I also wanted to comment something I've learned from working with you, Betty. You always encourage them to bring a draft settlement agreement
I
also,
do.
don't
Yes.
you?
Yes.
I
I
do.
do. I do as
Yeah.
well.
Just it expedites the process. What I know is that settling the agreement itself can take hours, depending on how complicated the terms are. And there's a lot of back and forth among counsel, but I feel like it's really critical to get the agreement done, if at all possible, and not rely on a term sheet. I'm going to be mediating a case in which the term sheet was done 13 months ago and they still
Mm.
have not been able to get it into a fully complete settlement agreement. We're starting the process all over again. So I'm not a fan of term sheets if they can possibly be avoided. I know sometimes it's too late. People are too tired to go through the process of documenting the agreement that's been reached, but I try and avoid them at all possible.
Yeah, and you know something, I always ask for a draft ahead of time. Most of my matters, the attorneys are able to do it because you don't want to walk out. On one matter, a mediation that I had where they hadn't done it, one of the parties was getting tired of waiting for it and wanted to leave the mediation. And I want everybody to sign off before they leave.
Right,
Um, that makes it possible if you've got a draft.
right,
Mhm.
right.
Well,
So
you'd know personally about staying late there, Betty. I believe you hold the ADR record, staying until 2 in the morning to get
2 in the morning. No, I
negotiations.
think someone went longer than that, but it
Ah,
was a long day. But it was
too
worth it.
bad.
And they only go really late if the cases are settled and you're spending hours to document the agreement.
Mm,
Generally, they wouldn't go that late, but it's not unusual that they go, they're scheduled to go for 8 hours, but oftentimes can go 10, 11, or longer.
mhm. Well,
So,
we are just about at our 1 o'clock point here, so I do want to let everybody know that we'll be wrapping up the program portion of our presentation. If you do have to head back to work, we do understand you'll receive the full CLE credit. Again, that will come via email within the next week or so. And, if I get that legal specialization confirmation from the Cal Bar, I will send an updated version of their certificate as well. As you leave the program, you will be directed to a short survey where we really appreciate if you take a couple of minutes to let us know how we did and especially any thoughts for future programs that you'd be interested in seeing. But I do see that we have some questions stacked up here, so I'd love to pitch a few to the two of you. The first I'm going to ask is a kind of combination of several questions we've gotten about professional trustees. We've talked a lot about family member trustees and how to deal with them. That was the course of our program today. But if somebody did say, want to get a professional trustee for their dispute, how do they go about doing that? What are some concerns or considerations they might undertake? Especially if somebody doesn't have family or doesn't want to appoint a family member.
I think there's a lot of really wonderful professional fiduciaries, and the questions I get asked most are how do they charge for their services? So some would charge on a percentage basis, others may charge by the hour, depending on the nature of the trust assets. And then interviewing them. I mean, I know that they're used to being interviewed in terms of do they seem like a good fit for this family dynamic that you're dealing with. Sometimes a bank is the best alternative, depending on what the assets are. A lot of it depends on the assets. You know, is it a big apartment building that's going to be in the trust? Is it oil and gas interests, which are a unique asset that not everyone is interested in managing? Is it just a big brokerage account that's easy to manage? And so I think those are considerations for you. And then also the age of the fiduciary that you're talking to. They need to outlive you.
Well,
So,
also the experience they may have. I mean, we've
right.
got some new fiduciaries in LA County. So, you would want to like get their resume, find out how many years of experience, what kind of cases they've already managed, and the composition of the assets that they managed.
And how busy they are, and are they relying on staff? I mean, some fiduciaries are kind
Mhm.
of like sole practitioners, it's just them. Others have considerable staff, depending on how many trusts they manage and how big those trusts are in terms of the assets that they're in control of.
Mhm. Thank you. Those are great. Really address a lot of the questions we had there. Another one has to do with the unrepresented beneficiaries. We have seen a rise of those since Breslin in 2021. So how do you handle those unrepresented beneficiaries during mediation? You know, they don't usually provide a mediation brief. They don't often know anything about the process. They just show up. How do you deal with them in the actual course of the mediation?
Well, sometimes they're aligned with someone who is represented. And if the lawyer is comfortable with that, they could be in the same room with them, with the understanding if that lawyer wants to have attorney-client communications outside the presence of these other beneficiaries, then they're going to have to move. They're going to have to move into another room, whether it's a Zoom breakout room or in person. Um, Other times it's trying to give them
Are
information.
you there?
Yeah, and without giving them legal advice. So at ADR Services, they sign a form acknowledging that we don't represent them and that we're not there to be their counsel. So they agree to that. Um, Oftentimes, it's not a problem, particularly if they're aligned with someone who is represented by counsel. And other times it's a real challenge. You just never know. But you have to respect that they have strong opinions. They may not be based in reality in terms of what they can expect the outcome to be, but it just takes time. You just have to be patient.
Well, and I think I agree with all that, and I think you have to treat them, treat them as courtesy. They're a party; they're there for a reason, and they want to be heard just like everybody else.
Right, right.
Mhm. And I think I'll lead us out on a final one, which is quite fun. So, how do you handle family members who perversely enjoy fighting their siblings in court?
And we have those. I had a case recently in which family has been litigating for decades, even when the parents were alive. They litigated, the parents had given them fractional interests in real property, and they litigated over that. You know, there's sometimes it takes a judge. You know, I feel like it's not perfect in every situation. And if people are really so motivated to continue the fight, then it may not be worth spending the time and money on mediation. I mean, I think it's worth a try to see if they finally are in a position to make reasonable decisions, but that's why we have the courts.
Mhm.
So I saw a couple of other
No,
questions.
I agree.
Um, so there's the formula for valuing a life interest. It's based on an Internal Revenue Code section and the actuarial tables. And I'm not able to tell you off the top of my head what the Internal Revenue Code section is, but most estate planners would be able to figure that out. Um, so um, then there's a question about personal property claims with high emotional value. And there's no question that beneficiaries will admit this asset may not have any financial value, but it's got very high emotional value. Those are the most difficult to resolve because you can't just equalize that value with dollars. And so that may be where you do an auction to see who's willing to pay for something that has high emotional value. There's different ways of approaching that, but I've conducted auctions where people just bid for that item, and the value, the dollar amount may have really nothing to do with the actual value of the item if it's got this high emotional value attached to it. Yeah. Oh, what other are there any questions? So someone might disagree with an end of life decision being determined by the doctor. Seemed like that was a pretty critical decision, and doctors, I would hope, would take it very seriously whether someone is really competent to make that decision. But the case settled, so that was okay. So there's a question about how to deal with the counsel of a trustee who refuses to provide bank statements, credit card statements. I can't imagine on what basis they would refuse to do that. And the option is, if you've got litigation going, is to subpoena them. Certainly a trustee should be willing to produce all of the backup data for the accounting that got prepared. Make it available in someone's office. They can review it, they can make copies of it. It should be made available. And so you can try and educate that attorney that that's not consistent with a fiduciary's responsibility, or you can subpoena the information. Oh.
One of the questions we answered did also have a note. Somebody asked if ADR Services serves as the trustee ever. And just to confirm, no, we don't do that. We also won't hold funds in escrow or anything. All of our panelists are fully neutral.
Right. And I will admit that when I was with the law firm and my partners would come to me and say, I've just been asked to serve as a trustee for someone in my family, should I do it? My answer always was no. It is a truly thankless job. Now, it can be rewarding if everybody gets along and the job gets done relatively smoothly. But otherwise, and when trustees are feeling under attack, I tell them that in my view, it's a thankless job. And that really resonates with people. They really appreciate hearing that, that no one appreciates the time and the energy that it takes to fulfill their fiduciary obligations. But my feeling is no, we wouldn't want to do that.
Have either of you ever served as trustee for a family member?
I served as co-trustee with my brother, and determined that we were going to be the perfect co-trustees of our mother's trust, and it worked. My attitude was, I don't care what happens. I'm not going to get into a dispute with him. It's not worth it. That my relationship with him is more important than whatever the dollars are that may be dispute. And it turned out we had no dispute. I told him recently that I thought we were model co-trustees. Generally, I refer to co-trustees as co-trusteeship by committee, and it oftentimes does not work. It's challenging. I'm mediating a case in a few weeks in which there are 3 co-trustees, all siblings.
Are
And
they getting along?
apparently they are at the moment. We'll see what happens. Things can change, but for the moment, they're not adverse to each other, but they're adverse to other beneficiaries. This was a big family. There were 6 kids. And out of the 6, 3 are co-trustees. How that occurred, I don't know. But I'm not a fan of trusteeship by committee.
What about you, Carmen? Have you been a family member's trustee or administrator?
Yes, but I was the sole trustee, which it goes to Betty's point. It's better to be by yourself and do it yourself than to do it by committee. And I got along well with me.
All right, well, we are at 10 minutes after, just in cognizance of everybody's afternoon. I am going to close us out here. I do want to note that both Betty and Carmen put their contact information in the handout materials. If you have any follow-up questions or need to get in touch with them, you can contact them at their email addresses or to contact their case management teams. For Betty, that will be me, and for Carmen, that will be Chelsea down in Los Angeles.
I love the little hand clapping that shows up in our Zoom. That's so fun. And thumbs up. Thank you for your feedback.
Thank you, everybody, for joining us. Thank you so
and we
much
got
for
some
Carmen and
hearts.
Betty.
Oh yes, thank you for your attendance and
Yes.
your kind hearts.
Yes.
Well, thank you, everybody, and have a wonderful afternoon.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.